Good morning. I'd like to call to order the zoning hearing for Wednesday, September 16th. Let's begin this morning with the Pledge of Allegiance. Please rise. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. Okay, we have one case on the agenda this morning, so I'll ask our staff to introduce the item. Good morning.
Good morning, Commissioners. How are you?
Good.
Dave Loveland, Community Development. I'm just going to do a brief introduction just to kind of lay out this sort of unusual process, and then I'm going to turn it over to Russell and the applicant's team to do their presentation first, and then staff will follow with our presentation. I just wanted to make sure everybody was aware we're dealing with a unique process under our Land Development Code, Section 12109E. You'll keep hearing references to 109. That's what that is. That's a special. Section 12, as you know, in our Land Development Code is where our mining regulations are. This is a special provision that allows aggregate mines approved prior to September 9, 2008 to ask the board for a time extension and some changes to their zoning conditions that would bring the mine into greater conformance with today's regulations. That provision was created in 2010 actually as part of a settlement agreement with Florida Rock, which included some of the same players that are here today. It was tailored to their circumstance, and they're the only ones that have used the provision so far to consolidate some phases of their mine. So because it's under this process, it's not the normal formal zoning action. So it bypasses the hearing examiner. It comes straight to the board for your action. So you're not bound by the quasi-judicial process for a normal zoning case and the reliance on competent substantial evidence. This is purely a discretionary decision by the board then and how you choose to deal with this request. You can accept it, you can deny it, you can put conditions on it, you can do what you feel is appropriate. And anyone from the public is eligible to speak. We don't have the restriction that you had to go through the hearing examiner first. So in this particular case, staff is recommending that this isn't the appropriate process. We have a procedural issue that we're highlighting, that this isn't the right process to seek their request, and they should go through the MAPD. They'll be arguing why they think it's the appropriate process, I assume. So I'll turn it over to Russell and his team.
Chairman.
Commissioner Pendergrass, go ahead.
So Dave, you said earlier on this was designed in 2010 for aggregate mines, the Florida Rock, correct? So is this item before us today is this an aggregate mine? Because they are already allowed to excavate rock and crush it. So is that considered an aggregate mine?
Well, that's the crux of the discussion today. Staff does not feel that it is. I think the applicant is going to argue that they think it is.
So is that opinion or is it facts based upon code or policy that it's not an aggregate mine?
It's fact based on how we interpret the record.
So we've usually defined, like we've done in the past for mining, if you excavate rock and you process it on site, which they're approved to do, that would be considered an aggregate mine, correct?
The difference is the definition. We don't actually define aggregate mine in our code, but we have a condition that relates to this project as part of their zoning. It says they're not allowed to be a commercial structural materials mine. And the difference is being able to sell it. You're pulling it out and processing it for commercial sale for others to use.
They can sell the dirt that was next to the rock.
They're approved as a dirt mine. They can sell the dirt. The rock is assumed to be incidental to their operation to obtain the dirt. They can process it and get it out of the way and utilize it however they want. They can't sell it.
Where would they put the rock, though, during that process?
That's up to them. They could leave it on site, stack it up on site, or they could take it off site somewhere else.
If they did that, would it be a water quality issue with lime rock exposed based upon elements of rain and water runoff? Would it be more of a runoff issue then for water quality issues?
I don't know if I can answer that question. I think it would kind of depend on the circumstances. I'm not an expert in that particular field.
Okay, thank you.
Any other questions for our staff at this point? Okay, good deal. And Mr. Levin, did you have more of a presentation by our staff then? Or?
Yes.
Okay, very good. Well, before we get to the applicant, do we have more staff presentation?
Yes, sir.
Okay.
Commissioner, our presentation in chief would go after the applicant, if that's okay.
Oh, staff will present after the applicant.
If that's okay.
That's not how we traditionally do it.
Actually, we have been having the applicant go first in a lot of our cases.
Okay, just usually here at the board, it always goes staff, then applicant, then public, then back to the applicant for rebuttal, and then the board discusses and votes.
We can do it either way at the chair's
Does the-
discretion.
Yeah, I mean, I
Either-
guess I'd rather keep it consistent with that. I'd love to hear the staff first.
Okay.
Uh-huh.
All right. So, as I had mentioned, under Section 12109E of our code, this lays out how it's actually worded. Applicants with aggregate mine zoning approvals can seek this time extension from the board up to 5 years and modify their zoning conditions in order to bring it into greater conformance with existing regulations. Again, staff is recommending denial. We don't believe this is an aggregate mine, so this isn't the appropriate process. It was approved as a fill dirt mine. We think it's very clear that it was always intended to be a fill dirt mine. Any rock processing would be incidental to that. We don't believe that the request to basically allow them to do rock mining on a larger basis brings it into greater conformance with today's regulations, because under our regulations, any lime rock mining is supposed to go through a Chapter 12 review process. So we feel they should seek what they're asking for through that Chapter 12 mining, excavation, plan development, rezoning process. The applicant's request is to extend the master concept plan for their 500-plus acre project, which you can see highlighted here. It's outlined in red. It fronts on State Road 82, Lehigh Acres across the road. You have Cicada Seed immediately next door to the west. So the Troyer Brothers property is just west of that. And then the old Corkscrew property that also had a mining request that was denied is to the east. The applicant's asking specifically to remove the restriction in Condition 12 of their existing zoning, which was approved in 2004, that prohibits construction materials mining as defined by Florida statute. And that's highlighted because that's sort of key to all of this. They're also proposing to revise their reclamation plan to increase the littoral zones, post-mining activity, and to include a condition for some water quality monitoring.
Real quick, Dave, so those last 2 points about the littoral zones and the water quality baseline and monitoring and review, are those like newer conditions basically that we've come up with today because we're more concerned about water quality than maybe they were back in the 90s? Or?
Those are conditions proposed by the applicant, presumably to address some of today's issues that we normally see.
Okay, thanks.
So this is a blow-up of the site with the master concept plan overlaid on it, so you can see the footprint of where the mining activity is, and then the areas with some wetlands that are to not be mined the way it's approved today.
Okay.
So going through the zoning history, it was originally approved in 1990 and permitted specifically as a fill dirt operation with a 40-foot depth. And there was a specific prohibition on blasting in the original approval. And there was a finding actually stated in there that said it's consistent as it relates to an industrial plan development for the purpose of fill pit operation only. There was a modification later that came to address hazing issues about that same time frame that still had that same finding language in there. In 91, there was a removal of the prohibition on blasting and some conditions related to then if blasting were to happen, I think that was in response to the state superseding local government's abilities to regulate blasting. So they have, any blasting activity has to be approved through the state fire marshal's office. 2004, they did an amendment to that IPD zoning. I think there had been some period of inactivity that they then wanted to bring this forward and update. And throughout that record for that, it was clear that the understanding of all the participants, and this would have been the understanding then of the public and the board, was that it was a fill dirt operation. In the applicant's own compatibility analysis, they stated the project's to mine fill dirt, not rock. Blasting is not proposed. Only rock encountered incidental to fill dirt mining. The staff report made clear the applicant's proposing a fill pit operation. In talking about comp plan consistency, the staff report made clear the applicant's requesting a limited fill pit operation. The hearing examiner had that understanding in the hearing examiner's recommendations. She noted that they're requesting, the same 40-foot depth, incidental rock crushing. There will be no mining of lime rock or construction material. Blasting is not necessary and requested. And this condition 12 was included in this 2004 rezoning that said very specifically, construction materials mining as defined by Florida statutes is prohibited. There was an administrative amendment in 2014 which did away with the maximum duration that was in there and the phasing schedule, so then they would be subject to the standard 20-year life that's under our code, plus whatever legislative extensions are granted because of emergency situations. So currently their zoning approval goes through October of 2029. They also have a limited development order and concurrency certificate that's good till 2031. They have a mine operations permit that's good to 2037. And they have water management district and DEP permits. So the project was clearly intended to be a fill dirt mine operation based on the approvals with the ability to deal with some incidental rock encountered during the dirt mining because that's normal. So that limitation on construction material mining is key. It wasn't defined in our land development code, but the condition referred to the statutory definition that was in place at the time. In 2004, Florida statutes said construction materials mining activities means extraction of limestone and sand suitable for production of construction aggregates, sand, cement, and road-based materials for shipment off-site by any person or company primarily engaged in the commercial mining of any such natural resources. They're, based on their approval, engaged in commercial activity for dirt, not for rock. So we have added that definition that reads very similar to the statutory definition to our land development code since then. So it reads virtually the same in section 12105 of our code. And we also have a separate definition for fill dirt, meaning materials suitable for use to improve land by distributing over the surface of the land to raise ground level above base flood elevation. And we include the statement, fill dirt is not deemed suitable for production of construction aggregate, sand, cement, or road-based materials. We made the distinction in our codes between a rock mine, aggregate mine, and a fill dirt mine. We have that distinction. What it seems to be requested here is just kind of eliminating that distinction. So from our perspective, we don't feel section 12109E is applicable because we don't feel they meet the definition of an aggregate mine approved prior to September of 2008. We also don't feel it meets the requirement that it would bring the mining operations into greater conformance with existing regulations because our current regulations require lime rock mines to go through this MEPD rezoning process and address all of the associated requirements. So this proposal kind of skips that process. They are proposing a couple of conditions that would relate closer to some current requirements in terms of the water monitoring in the littoral zones, but that's not addressing all of the aspects of Chapter 12. The Chapter 12 also has a reference in Section 12.121 about allowing for limited amendments to zoning approvals for mines approved prior to September 2008, but it specifically says that's limited to dewatering or an extension of the mine duration. And it says any amendment to an existing mine that constitutes a substantial change has to go through the MEPD process. A conversion of a fill dirt mine to a lime rock mine to us would meet the definition of substantial change. And the code goes on to say you can't expand your request for dewatering or extending the mine duration to include other amendments. And so it makes clear in there that then the limited amendment has to go, even if you could do it, it has to go through a hearing examiner review. So staff is recommending denial not only because of inconsistency with Section 12.109, but also this 12.121, because the request isn't limited to dewatering or extension of the time, and it hasn't gone through the MEPD process, and there's been no review and recommendation by the hearing examiner. Limited information has been provided through this process because they're not doing the full-blown Chapter 12 submittal. One piece of information that we thought was important that was provided to us was a technical memorandum from October 2019 by a consultant for the applicant, which gave us an overview of the geotechnical analysis for this site. So it looked at some soil borings that were done as far back as 2003. There was some additional soil borings done in 2017 and 2019. And their conclusion was this site had a consistent stratigraphy beneath the project site with 10 to 15 feet of sand, which is the fill material they are initially approved for mining, at the surface, overlaying 40 to 50 feet of limestone. Then beneath that, you got 10 to 15 feet of silty sand, which their report concluded wouldn't be financially viable to try to utilize. And then you get to 30 or 40 feet of dense clay. So once you get that 10 to 15 feet of dirt off the top, then what you're left with is 40 to 50 feet of rock. They're approved right now to a depth of 40 feet. So it's not a question of just taking rock then that's incidental to the dirt mining. If they have approval to remove and process and sell rock, they will pretty much be a rock mine. The applicant didn't address, because they didn't do a more detailed submittal of the various LEAP plan goals and objectives that we're supposed to review as it relates to construction materials mining. But that would be provided, that information would be available to us if they went through the Chapter 12 MEPD process, which we've been telling them in meetings for 3 years that we think that's the direction they should go. So to summarize, we've reviewed this request in relation to both Section 12.109 and 12.121. We think it should be denied because they don't meet the definition of an aggregate mine. It was clearly intended to be a dirt mine with some incidental dealing with rock. And we don't feel it brings the project into greater conformance with today's regulations because they haven't gone through the full Chapter 12 process. And we think the request constitutes a substantial change, which under Section 12.121 would require them to go through the MEPD process and through the hearing examiner review. So that concludes our presentation. Do you have any questions for us?
Very good. Commissioners, what questions do we have for our staff? None?
Let me just clarify one thing. They're clear to go down to 40 feet, correct?
Yes, sir.
Okay. 15 feet is what was anticipated of the dirt. So there's the balance is all rock. Is that correct?
That appears to be the case from the analysis that was provided to us.
Okay, thank you.
Commissioner
So,
Pendergrass?
Dave, I think I asked you this the other day, so I know you really can't give a good answer to this because we all don't know, because there's a lot of opinionated information here, but so if they went into the hex with no other requests, they didn't go beyond 40 feet, they didn't change the buffer, they didn't change anything other than what they already approved from 1990 and 2004 amendments, the hex would only be looking at, can they sell the rock they're already allowed to excavate, or they could not sell the land. So that's all they'd be looking at changing. If they could sell the rock they're already allowed to dig up, which is considered aggregate. Your professional opinion,
My professional
I think
opinion,
the hex's response would be,
if they had a limited request under Chapter 12 that went through the hearing examiner, because it's already an existing mine operation, that would limit some of what would apply and what you would be looking at. The removal of the condition would give them the ability to sell it, but then that would encourage them to continue to mine rock out beyond what might be incidental to the dirt mining.
if initially they didn't change the request, which is what they already approved today for 40 feet, the hex would probably allow them to sell what they're already allowed to excavate if they didn't change anything else.
Well, without a full application and going through the process, it's hard to speculate what the hearing examiner would actually approve.
Well, like I said yesterday, I think you have your opinion on the other issues. That's why I was trying to get your opinion on that. But that's fine. I understand. Thank you, though.
What other questions do we have for our staff? No? So can you go back to that one map where you showed the whole site with the boundaries and stuff? I'm a picture guy. I got to look at that. So just, so I see a couple lakes have been dug out already. But what you're saying is anything outside of the hatched area, or inside, I guess, of the non-hatched area, maybe up to the first 15 feet of that is the fill dirt sand that they could go ahead and mine off right now?
That would appear to be the case from the geotechnical analysis. They had soil borings all throughout the site, and that seemed to be what they viewed as consistent. It obviously would vary probably from location to location.
Okay, and so whatever rock they would encounter in that process, they're allowed to process and deal with. They just can't sell it. They've got to do something with it. But
Correct.
right. Okay, so that's interesting. So that's still a lot of truck trips and a lot of. I mean, that's a big mining operation that's currently approved, even if it is just fill dirt and not lime rock.
That's correct.
Okay, all right. All right, thanks for that, Commissioner Pendergrass.
On the northern portion along Sakita, that's all protected wetlands there, correct?
Yes, sir.
So that whole area is
identified
wetlands. That would never be,
as-
that's currently not going to be mined for dirt or gravel or rock or anything.
Under the current approval, no.
Okay, thank you.
Good.
That's a buffer.
Thanks. So that concludes the staff presentation then? Very good. Thank you for that. Let's go ahead and call up the applicant. Thanks, sir.
Yeah, how do I hit escape? Excuse me, Commissioners. This one?
That one.
Thank you. Sorry about that. Good morning, Commissioners. My name is Ron Inge, technically challenged, obviously. I'm one of the owners of the Bell Road Mine. I own it along with the Quentin B. McNew Family Trust. We acquired this property, hence the name MC for McNew, IN for Inge, Bell Mine. So I'm a partner with Quentin McNew's family in this particular operation. I appreciate the opportunity to be able to talk about our mine today and certainly understand and recognize the points that Mr. Loveland raised. My team is going to discuss what we believe are the facts relating to this operation and that it is, in fact, an aggregate mine, and we'll talk about that in just a few moments. I would like to introduce my team that's with me today. Tina Eggblad with Morris Depew & Associates. From Baracco & Associates, Mr. Carl Baracco, Mr. Wes Kane, Ms. Jennifer Sapin, Kirk Martin from Water Science Associates, Mr. Russell Schropp from Henderson, Franklin, Stearns & Holt, and Mr. Jeffrey Straw from Geosonics. The property that we're here to discuss today has been historically known as the Bell Road Mine. As Dave pointed out, it was zoned originally back in 1990. There's been a series of rezonings or additional zonings, if you will, and clarifications that have occurred since that date. Unlike most of the other mines in Lee County that have been approved over the years, this mine fronts directly on State Road 82. It doesn't reside in the Alico Road area like all the other mines do. This is right on State Road 82. And as you can see, the Bell Road mine is designated by the star up in the right-hand side. All the other mines are a little bit south of us because that's kind of the way the vein of rock runs. Briefly on the approvals that have been granted, the first approval in 1990 was for phase 1 of the mining operation. Then later on that year, phases 2 through 5 were approved. In 1991, there was an amendment to allow blasting in connection with aggregate production. In 1996, essentially the first phase was eliminated from the project, which is to the east side of the Bell Road mine now, and that piece that previously was partially mined and was part of the mining approval is now a commercial water ski school operation. It's just to our east, but that was at one time part of the mine. And in 2004, there was an amendment to the Master Concept Plan, which is the Master Concept Plan that we operate under today. Here's a little bit closer view of the property. Under the most recent zoning approval, the mine has 503 acres. It approves 261 of those acres for actual mining, with 189 acres in preserves. Those are the ones that were talked about just a few moments ago based on Commissioner Hammond's questions. 189 acres of this property has been placed in conservation easement, but not only has it been placed in easement, we've been maintaining that for several years, and just recently, within the last month, the Florida Department of Environmental Protection signed off on those wetlands as having been successfully mitigated for and meeting the success criteria that they deemed appropriate, so we no longer have to do any maintenance activity and just periodic monitoring. They're very happy with the success of that 189 acres that we preserved. It's about 40% of the site, so we're very happy about that. We're currently, as the slide shows, permitted to dig a lake 40 feet deep by 261 acres and remove the material out of that lake. And as you can see and highlighted here, rock crushing and screening is allowed for us to do. So the rock that comes out of that lake, we're allowed to crush and screen. The 2004 approval provided for all those activities. You can see them here. Excavation, which is what we're doing. Rock crushing and screening, which is what's been done in the past and what we can do. Open storage of those materials, and then some other uses that are related to the aggregate operation itself. But the point is, nothing that we're here to ask for today changes any of that. All those approvals, the depth, the size of the lake, the preserve areas, the number of truck trips, all that stays the same. We don't ask to change one iota of that today in this approval. Here's our problem, as y'all discussed earlier. There's rock out there that we can't sell. We can dig it, we can crush it, we can look at it, we can't sell it. Not sure what the purpose of that is, because we're still digging the very same lake that's been approved since 1990 and then modified through the conditions, additional approvals all the way up through 2004. If I may, let me talk a little bit about the history of the mine. Many of y'all know, but probably some of you don't. I have a pretty lengthy background in the mining industry, having owned and or developed mines in Southwest Florida over the years. So I know a little bit about the mining industry. And as a mining operator, you tend to watch what other folks are doing and try to learn what their strengths are, what things they have to face, because it's a competition that you're doing. You're trying to sell material to the marketplace just as they are. One thing that I learned by watching this operation over the years is that the operators ran into something they did not anticipate when some of the original zonings were done. There was way more rock on site than what they thought. Before all the extensive work was done to do the geotechnical analysis way back when, they thought this was going to be primarily fine aggregates, or fills, some people might call it, but finer aggregates. That's not the case. There's a lot more material, coarse aggregates, that underlie the surface, the first 10 to 15 feet of the surface. So the inconsistencies in that 2004 zoning resolution, specifically Condition 12, is the one that causes problems for the prior operators, and certainly is a problem today. As I mentioned a minute ago, we can dig it, we can crush it, we can size it, we can't sell it, which seems to be an issue that we can't quite get our arms around. In 2013, 2014, I was asked to get involved in looking at this mine on behalf of a prior owner, a bank at the time, who had foreclosed on the property, They wanted to make sure that they understood what the permits that they had on the site were, what was required of them, what they needed to do to go forward, and to make sure that the house was in good order. Well, what I found out was that not only were the permits valid, and we went through those, but there were some code enforcement issues that existed that Lee County was trying to pursue, but through a series of owners and bankruptcy with one and all these things, they hadn't been able to get satisfaction to solve those code enforcement issues. So that's what we did. In 2015, I worked extensively with your staff to solve problems with the landscape berm that surrounds the property, and we're going to show that in a few moments. They were backdated in the maintenance efforts that they needed to do on the preserved areas that we've now taken care of. And there were some hydrocarbon spills on site that needed to be cleaned up as well. I worked with this prior owner, and we took care of every one of those and solved those to Lee County's satisfaction in 2015. Well, the prior owner before us wasn't quite sure how they were going to go. They engaged someone to come out and mine the property. They ran into the very same thing that the prior operators had done. Once they got through the finer aggregates, the first 10 to 15 feet, they ran into a layer of rock that they could not figure out what they could do with it because of that condition 12 that's in the zoning resolution. They knew that they could figure out how to dig it, perhaps, but they didn't know that they could sell it, and that was a problem because there was a significant amount. The majority of the material on site is coarser aggregates, or lime rock as people would call it, rather than the finer aggregates, which is the sand. So in 2018, I purchased the property along with the McNew family and had three things that needed to be solved. The first was, after watching it over the few years that I had, figure out just how much rock is really there. So I engaged two separate geotechnical firms to go out and do extensive soil borings. And as Mr. Loveland mentioned, they're extensive. There's a number of them on site. And what we found out is that the rock was harder and thicker than anyone originally anticipated back in the 90s. As it turns out, the 1991 zoning resolution approving blasting and discussing aggregate mine was correct. Coarse aggregate mine. It was right all along. The second issue I needed to resolve was why this mine did not appear on map 14. Wasn't really sure about why that was the case. I wasn't involved with this mine in 2010 when map 14 was created because that shows existing and future mines. Don't know why it was left off. Wasn't sure if that was an issue or not because we were already zoned. So I thought, okay, we still have an interest in that. So when a third party challenged the map 14 amendments, I realized that, you know what, we have a dog in that hunt. We probably should get involved in that because I'm not sure how it affects us, but just to be safe, we better make sure. So our team of Russell Schropp and Richard Aiken from Henderson Franklin, providing legal expertise, Tina Ekblad from Morris Depew, providing technical, planning, and zoning expertise, certainly related to the mining industry, and me on behalf of the mining industry talking about mining practices, the uses on mines, how the process goes. We joined with your legal team to address the challenge that had been filed against your comp plan amendments that you had adopted in 2019. The result was that cooperative effort worked. We won the case. And just 2 days ago, this past Monday, the Florida Department of Equal Opportunity issued a ruling that upheld the comprehensive plan amendments that you passed in 2019 and that we helped defend. That was step 2 that needed to be done to address the issues of Bell Road Mine. 1, figure out how much rock was there, a lot. 2, address map 14, done. The third was, what do we do about this conflicting zoning resolution that we have? Condition 12 says that we can't sell the lime rock material. That other language in the zoning resolution clearly allows us to crush. There are even designated hours in the zoning resolution that tells us when we can crush the rock. This inconsistency was a problem. So how do I address that? And that is to come before you today to try to address the odd occurrence that we have approval from you to dig a lake 40 feet deep, to dig everything out of there. We've placed all the conservation areas and easements. We've maintained them well. We've built a landscape buffer around us second to none. I just can't sell the material that I'm clearly allowed to dig and process. That's why we're here today. So what I'd like to do is turn over to my other team members to talk about the technical aspects of this request and to address the points raised by Mr. Loveland. Initially, Mr. Schropp is going to talk about the process and why we're following it and why we're properly before you today. Carl Baracco is going to discuss, in his professional opinion, why we are an aggregate mine. Because aggregate is comprised of a couple of things, one of which is fine aggregates, the other is coarser aggregates. Mr. Baracco, in his professional opinion, is going to talk about that. Next, Ms. Ekblad is going to talk about lead plan consistency, Chapter 12, and how we comply with those. Frankly, every point that you will see her raise are things that are in Chapter 12 that we've addressed already. And then I'd like to make a few concluding remarks after that. So if I may, I'd like to ask Mr. Schropp to come up, unless there are any questions that you may have of me.
Do you have any questions at this time? No? Okay, go ahead.
Thank you.
Morning, Commissioners. For your record, Russell Schropp with Henderson Franklin here on behalf of McKinn Bell LLC. And I will, if I can pick up with the things that Ron wanted me to address, which is the applicability of the process that we're involved in here. And actually, my presentation is probably going to be a little more streamlined because Dave Loveland did go through it with you, and I don't know that I disagree a whole lot with what he has indicated, except for one thing. But as Dave did indicate, this is a process that isn't used very often. It's fairly uncommon, and to my knowledge, it's only been used once before, and that was the Florida Rock case back in 2012 and 13 that came before the board at that time. The process that's provided under Section 12-109E is shown on the slide here, and basically I paraphrase the provisions of the section of this code. I would note that one area that I do disagree with Mr. Loveland on is that this is a process that is separate and apart from the other processes in your mining code, and particularly is separate and apart from the process that's provided in Section 12-121 for other amendments that are provided or available for existing mining operations. So what does 12-109 provide, 12-109E provide? First of all, under subsection 1, it indicates that master concept plans that were approved prior to 2008, which is the date your new mining regulations were adopted, that anything approved prior to that time is valid. The master concept plan is valid for a period of 20 years. In this case, the master concept plan for the Bell Road mine was approved in 2004, so it would normally expire in 2024, but we have obtained what we call the state of emergency extensions that are available under the statute, and the current expiration date for the master concept plan is 2029. The second subsection there of that section allows this board to grant one 5-year extension to the master concept plan, not exceeding 5 years, and that's what we're asking for, is to extend the validity of the master concept plan from 2029 to 2034, 5 years. Subsection 3 identifies the filing requirements for this type of request, and we believe we've submitted them, otherwise we wouldn't be here. Subsection 4 directs, as Mr. Loveland indicated, that this request be reviewed by staff and then proceed directly to the board. It does not go through the hearing examiner, and I think the reason for that is that this mine has already been reviewed multiple times by the hearing examiner and has been reviewed consistent with those procedures and has received prior approvals. Subsection 5, as Mr. Loveland indicated, the approval through this process with this board is discretionary. And subsection 6 really gets down to the condition 12 issue and the other things that we're trying to accomplish with this change. Subsection 6 allows this extension request to propose modifications to the conditions of the previous approval that are facilitate or provide for the mine to come into greater compliance or conformance with current regulations. And that's what we are proposing today. As I mentioned, and as Dave mentioned, the only other time this has been used is the Florida Rock mine. I will note in that case, and I was involved in it, as was Mr. Inge, the prior approvals for the Florida Rock mine number 2 were combined. There were multiple approvals, and they were basically combined under one set of conditions for that resulted in about 40 substantive conditions being modified, including things like the lake size and the shape, the hours of operation, relocating the processing plant, and I'll even tell you that the modification accommodated the Alico Road extension that you all are proposing to build at some point in the future. So they were very, very significant modifications that were accomplished through the Florida Rock case that we're not asking for here, at least to the extent. This application is comparatively much simpler than what was done for the Florida Rock case. As I indicated, I think previously, the request basically includes 6 things. Extend the master concept plan to 2034, eliminate condition 12, which, as we heard, really acts to restrict the sale of rock materials on the site, sale and transport off-site. Clarify the previously approved uses of rock crushing and storage activity. The 4th and 5th points there are things to bring the mine into greater conformance with current regulations, increase the littoral plantings and shelves that will occur after reclamation of the mine is undertaken, and also to add for water quality monitoring for the property. And then the 6th thing there would simply require that the development order and the mine operation permit be updated consistent with this request. In the staff report and in Mr. Loveland's presentation, staff raised what I will call a threshold issue, and that is, are we even eligible for the process in 12109? Because as we've indicated, and as Mr. Loveland talked about at length, this process is applicable to aggregate mines. And so the question basically is Bell Road Mine actually an aggregate mine? As I indicated, the process is applicable to aggregate mines that were approved prior to 2008, which is the date that the new mining regulations were adopted in Lee County. Frankly, I think it's clear that the Bell Road Mine is an aggregate mine for a number of reasons, and I'd like to have Carl Baracco basically address you briefly on the technical aspects of aggregate material to basically qualify this as an aggregate mine, if I could, please. And then I'll get back up.
Commissioner Pendergrass has a question.
Russ, I'm sorry. In the picture, the pile up there, is that dirt or is that rock?
That's rock.
Okay, that was my question earlier. I was trying to point out, and I'm glad to see you have water quality, because when you have rock like that, I know from living here all my life and playing at Old Lakes Park when I was a kid, when it was Harper Brothers Mine, that stuff is exposed like that, and that's what I was asking about the runoff earlier. When it's exposed like that, if you can't move it off the property and sell it, that was my concern. If you store it, the runoff between the sulfur and all the other minerals was in that lime rock. Once it's dug up, it's exposed, and Commissioner Mann, you probably remember as a kid playing, out east or something, when you have places like that, when you have the runoff, how it damages, it kills everything around the area because of the sulfur and everything's in the rock. And that's why I was asking, if you can't remove it, is that creating more exposure for water quality issues than being removed off the property and used somewhere? You know what I mean? So that's why my question was earlier. If that's how you're storing it, that's my concern about that. So that's.
And I don't know the answer to that,
Yeah.
but I'll ask and see if I can get an answer.
I'm not a scientist when I'm saying I just know what happens in that area after it sits there for a few months and it rains and the runoff, and I know what it does to the area around it if you don't remove it. So
We'll try and
thank you.
In the meantime, let me.
I'm sure Kirk can answer that question. So
Yes.
Thank you.
If I can get Carl up here to address the issue, which seems to be a threshold problem here for staff.
All right. Mr. Baracco, you are recognized.
Good morning, Commissioners. For the record, Carl Baracco. I'm a professional engineer and president of Baracco & Associates. I've been requested to provide a professional opinion of the Bell Road Mine activity. And Bell Road Mine has historically and continues to produce fine aggregate, the sand that you've talked about, and also coarse aggregate, lime rock, which you've heard about. So to categorize the Bell Road Mine activity, I first want to go through some definitions. And the first is an academic definition, and that is from the Civil Engineering Reference Manual, 14th edition. And they define aggregate in 2 different ways: fine aggregate and coarse aggregate. Coarse aggregate is a natural gravel or crushed rock greater than or equal to 4.75 millimeters in particle size. That's the larger aggregate. Then the fine aggregate is also described and defined as natural sand or crushed stone less than that 4.75 millimeters, but greater than the 200 sieve. And the 200 sieve is just another particle size, which is 0.075 millimeters. And that range for the fine aggregate between 0.75 and 4.75 is the actual particle range for sand. So you've heard about sand, you heard about fill. That's all fine aggregate. So that's the academic definition. And then I wanted to come closer to home and look to the Florida Administrative Code. And I referenced Chapter 14.14-103. That happens to be the same section that staff references in their report. And it is also the same section that the FDOT, and that's the letter in front of you, which I'll get to later, references in their findings regarding the lime rock aggregate mine, material from this mine. So we're all using the same definition, and it's a lengthy definition. It is in the staff report. I'll just read the first portion, unless you want me to read the whole thing. Aggregate means a granular construction material such as sand, lime rock, limestone, gravel, shell, etc. So it includes sand, fill, it includes lime rock, as well as many other types of aggregate. Next, I want to look at the definition of aggregate by looking at Bellwood Mine itself, and that brings us to the FDOT letter. Somewhere around 2010, the FDOT was asked to look at the Bellwood Mine and consider that material as an FDOT source for lime rock. They did that and found that the material from Bellwood Mine was in fact suitable to be an FDOT certified lime rock, coarse aggregate lime rock base source. Again, their finding was based upon the same Florida Administrative Code 14-103.
Before you move on from that point, that was one of the questions I wanted to ask today. So it is FDOT quality rock. Is it the kind of rock that could be used on the widening of State Road 82 if it was necessary?
Exactly. With the FDOT certification, that lime rock can essentially be used in any situation that lime rock is required.
Good deal. And maybe somebody can address later in your applicant presentation if you guys have an agreement or if there's some, possibility or potential for this to be used on that widening project. I know it's ongoing and will be continuing for years. So.
I think Mr. Range will be able to address that.
Okay, great.
So we've gone through the definitions, and I would like to say that Bellwood Mine production includes mining of the sand material, which I talked about, and the lime rock material, which we talked about. Bellwood Mine has been and continues to be an aggregate mining operation. I wanted to deviate a little bit, though, because you've heard about a fill dirt operation. And I think you've seen that there really is no formal technical definition for dirt. It's the definitions that I've been talking about for soils and that sort of thing. But if you talk about fill dirt or fill material, you're still talking about that sand material, which, going back to definitions, is an aggregate material. So no matter how you cut it, this mining operation is an aggregate mining operation. In other words, the sand material or the fill material is one of several different types of aggregate, nonetheless an aggregate. So in conclusion, in my professional opinion, based upon the definitions that I've reviewed and based upon over 42 years of experience in the construction industry in Southwest Florida, Bellwood Mine has and continues to operate as an aggregate mine operation. That concludes my opinion. If you have any questions, I will take them now, or I can turn it back to Russell.
Any questions from Mr. Baracco?
I don't think so.
Commissioner Pendergrass?
Back on what the chairman's question was about the purpose of the use of the material. We saw in the picture there, which I'm glad you had that picture because it kind of gives an actual common sense view of what we're dealing with here. Because I know that's just one of many projects in Lee County and the region as far as like the road. But, you know, if the product doesn't come from here, it's going to come from somewhere else. So I know that no one, at the end of the day, we all talk open here. Nobody wants to mine in their backyard. I get it. It's my backyard. But it's going to come from somewhere, either Alico or Corkscrew. It's not going to create more trips because it's going to come from somewhere. So I get that. So I'm just glad you had that one picture to show the exposure of that product laying out. You know, it's just lit so they're waiting to use. And that's what the ask is today, is to so you can use it. So.
Yeah, and I think what we're talking about is, I'm not suggesting there should be a mine on every corner in Lee County. But in this case, we have an active mine. It has FDOT certified lime rock. And to give you an example, and I think this is where you were going earlier, if we have a lime rock pit within 3 miles of a need, and we have another pit that's 6 miles from that need, the closer truck is going to have, for every trip, and it's going to be the same number of trips regardless of what mine it comes from, will have 3 miles to the source and 3 miles back, 6-mile round trip, which I call a truck trip lane mile. The other source will have double that, 12 miles. So in essence, if we have this source available, and economically, Ron will tell you that typically it's the closest source that is producing that, we can significantly reduce the truck lane miles in Lee County where we need that material, regardless of where it comes from, it's needed. Is that, I think that's what you were saying.
Well, yeah, it comes back to, we heard this before, that needs assessment. So if you have this product already, then it reduces actually the need somewhere else. So actually, hopefully we'll reduce mining somewhere else because we don't want to mine every corner. And so that would hopefully reduce that need because you already have the product sitting there. So,
Exactly.
Thank you.
Thank you.
Any further questions? All right.
Commissioners, before I continue, I did talk with Kirk Martin about the question Commissioner Pendergrass has, and if I could just get him up here to explain the water quality aspects of the question you asked. So.
Excellent. Good morning, Mr. Martin.
Good morning. Thank you. So your question about is there potential water quality aspects of leaving rock above ground? The answer is yes. The concern would be more from a turbidity standpoint, just runoff anytime you stack material and leave it there for long periods of time. Your question about minor constituents, chemical constituents in the rock, it's mostly calcium carbonate. There are minor things, phosphate, arsenic, things like that, but they're very, very limited. So my main concern would be turbidity. And again, we stockpile materials all the time, but it's usually stockpiled for a limited time to move off-site. What we're talking about here is stockpiling and doing nothing with it, which is a longer-term issue, I would suggest.
Thank you.
Thanks.
Thank you. And so the last point that I need to address really has already been brought up by Mr. Loveland, Mr. Hinge before me, and that is the nature of the definition for construction materials mine really is a definition that applies to the sale and transport of material off-site. As you can see from the definition, the section of the statutes that provides for the definition of construction materials mine provides for the extraction of limestone and sand suitable for production of aggregates for shipment off-site by any person or company. And so that's really what the net effect of Condition 12 is here in terms of the mine operation. It's not preventing the extraction or removal of the ground of the material. It's simply preventing the sale and transport off-site, which to us just doesn't make sense, and is one of the reasons why we've asked for the condition to be deleted and as part of this clarification. That basically concludes my presentation, Carl's presentation on the threshold issue, as I call it. If there's any questions of me, I'd be happy to address them, but if not, I'd like to get Tina Ekblad up here. Because staff basically found that the mine did not qualify to go through the process, I don't think there was an analysis of the typical code and planning issues presented in terms of the staff report. So I'd like Tina to briefly go through that, and that will, and then Ron will make a few concluding remarks, and that'll conclude our presentation. So, Tina,
Okay.
you're available. Yes, she is. I'm sorry. Yes.
Okay, Commissioner Sandelli.
Going back to the picture which you brought up, it's evident right now you're just pulling out and storing it. What's the alternative to that if you can't move it off site? You just continue to store it on site? That's your limit?
It sits there, or it gets pushed back into the lake. Or it gets pushed back into the lake would be the two options that I would see. I don't know, Ron, do you have? That would be it. It would either sit there or just get pushed back into the lake at some point.
Well, Commissioner Manning had a question, and then Commissioner Pendergrass. Commissioner Manning.
Would you give us your thoughts in terms of the overall picture here? The reason I say that is because I seconded the motion in 1990. Bill Fussell made the motion. So.
Yes, sir. From the standpoint of this application, I think you've heard already enough from both sides to get the logistics of it. Staff is correct. The initial intent of this project was to provide for fill dirt. The applicant is also correct. The type of mine that this is not limited to fill dirt. When you go through the approvals in 2004, which I think Russell and staff kind of hit on, what you'll get is a very serious conflict between the condition 12 and ultimately the approvals. And what I mean by that, Russell, you could go, I don't know if you can go back to the slide that shows the uses that were allowed under the zoning resolution, but the zoning resolution provides for excavation mining. And if you could bear with me for a moment, I think our own code kind of helps answer some of these questions that the staff is getting into, and I'll be quick with it. And these are and I went back since '86. This was probably the regulations that were ultimately being used when this thing was first created. In the definitions of excavation mining that have occurred from '86 to today in the Chapter 12 are nearly identical. And excavation mining means the stripping, grading, or removal of any process of natural minerals or deposits, including but not limited to peat, sand, rock, shell, soil, fill dirt, or other extractive materials from their natural state and location. Excavation mining was authorized and has been authorized on this site, and it has been deemed an excavation mining for all those materials since then, and which would include aggregate and other subsets of those materials. As Russell was getting into, he correctly indicates that the distinction between construction materials mining really comes down to the shipment and the use of, commercial use of it off-site. In addition, you'll see rock crushing and screening. I don't think we've gotten into that yet, but that is actually a definition. That is a specific use under our code, and it is very important for the board to understand what that is. And that is, rock crushing and screening means a facility comprised of systems used for the automated conveying, crushing, segregation, and blending of crushed rock in order to manufacture the basic materials used in construction such as concrete, concrete block, cement, asphalt, road base, and many other rock products. That was authorized in 2004. Then you have open storage of the materials, as you saw in the previous picture. That is something that is authorized. What you then have, you have a condition 12 that provides you can't do that. Well, how do you go into a series of conditions that even have hours of operation for those conditions would allow for the extraction of aggregate, extraction of the fill dirt? If you agree that those are two different things, I think Carl just indicated they're one and the same, just subsets of the other. What you end up with is a condition that doesn't seem to stand on its own. So in order to rationalize the authorization that was approved and the condition 12, it is my opinion that the mine allows for the excavation of aggregate and any variance of the materials that were identified in the definition for extraction mining. But you're only allowed to sell the fill dirt. You're not allowed to sell the aggregate that is produced from this site. They're allowed to go down to 40 feet. As the staff and the applicant have indicated, they can go down to 40 feet. They can take the piles of rock and they can transport it off-site. They can't sell it. So the only difference between the definition that Russell was getting into and ultimately the prohibition and the regulation is the ability to sell it for commercial use. And what we're looking at today is a mine that allows for the excavation of aggregate and the sale of fill dirt with the limitation of the sale of the aggregate. Your uses under the code as they existed since 86 at least through today would identify the ability to extract the aggregate from this site. And overall, the process, there's one other element that needs to be addressed. Once you get past the threshold question is whether this is or is not an aggregate mine, which I think the applicant's already done significant work on that. The question is whether or not the proposed changes are consistent or brings the project into greater conformance with the regulations as they exist today. Staff has indicated to you earlier, and I don't think we've got into it from the applicant yet, staff has indicated that their position is that going through this process, the 12109E process, isn't in compliance with Chapter 12 and therefore doesn't bring the project into greater compliance. I suggest to the board that that is not a correct way of reviewing this. The proposed master concept plan changes and the condition changes are what need to bring the project into greater conformance. Now, what does greater mean? It means closer to. It doesn't mean equal to. It doesn't mean exactly. We cannot look at this process as indicated by staff that by going through this process you're not in compliance because you didn't go through MEPD. That's a circular argument. The entire process that we're in right now is intended to avoid for existing mines to have to go through MEPD. To say you can't go through that process, but go through that process, it is a bit problematic. So if the board agrees with the applicant that this is an aggregate mine, or at least it allows for the extraction of aggregate materials, then the threshold issue is resolved, and the question then before the board is whether or not the proposed changes and conditions that are being discussed by the applicant or will be discussed by Ms. Ekblad are in greater conformance. Now, I highlight that because I can't tell you what greater means, other than moves from not in conformance to somewhere between that and conformance with the exact regulations. So at this point, I don't know how much more the applicant wants to go through, but I think it is important for the board to hear the compliance with the lead plan issues that Ms. Ekblad wants to go through, but I think it really needs to turn at this point to whether or not the proposed conditions and the changes in the master concept plan, if any, are in greater conformance with the regulations.
Does that answer your question, Commissioner Mann?
What a memory.
I'm going to ask him if that answers his question.
I'm sure he remembers everything from 1992. So.
Very good. Do we have any further questions for our attorney about his explanation there?
God, no.
No? Okay. So,
When I'm looking at stuff in 1986, I was 8. So when I'm looking at that stuff, I've spent a lot of time trying to figure out what aggregate was and what it wasn't, what our codes say, and I can tell you without doubt that this process from 1990 through 2004 has authorized the extraction of those materials, and it went even further in 2004 to allow the processing of it, but it left off, okay, now what? We've got stockpiles of this processed material, and from our standpoint, the limiting factor is the ability to ship it off-site for sale.
yeah. So to really just kind of oversimplify things, and I'm sure you'll correct me if I'm wrong, but so 2 parts here. Number 1, they had to prove that they met the threshold that they are an aggregate mine. We've had expert testimony today and an application or presentation here on why they do meet the threshold of an aggregate mine. Step 2 is now, does the proposed changes bring it into greater conformance? And I believe that's the part of the presentation we're on now?
Yes.
Okay, very good.
Hopefully.
And as I indicated, I did want to bring up Tina Ekblad to run through the planning and code concerns and whether this is bringing the project into greater conformance with current regulations. Go ahead. One of the things we included in our application materials was a proposed resolution with certain findings and things of that nature. That was not included in the staff report, so that's what Tina is passing out in advance of her presentation for you to have as we go through this. But with that, I'd simply bring Tina up to address the planning and code considerations, including whether the changes we're proposing bring the mine into greater conformance. Thank you.
Good morning, Commissioners. Tina Ekblad, Planning Director at Morris DePue Associates. You've heard a lot about the specifics regarding extraction and the approval of the mining operation. I do want to kind of walk you through some of the bigger picture items and take a step back here. I agree with Michael Jacob that the extraction is approved. This is a mining operation for aggregate, as you heard Mr. Bracco testify to. The resolution that I passed out was included in the application materials, and I'm going to walk you through the conditions that are being carried forward from 2004 and how they do meet the intent of Chapter 12. I want to start with the hours of operation. You've already been walked through the request. That is staying exactly the same. You'll see it on the second page. Just below that, in condition 1C, you'll see the hours of operation for the accessory uses. I want to point out that rock crushing is allowed to occur Monday through Friday from 8 to 4, which is effectively the hours of a regular commercial business. The remaining accessory uses and the hours of operation are generally from 6 a.m. to 4 p.m., with the dragline being allowed to occur a little bit longer. This is actually more restrictive than the hours of operation that were approved for a recent MEPD to the west. So just putting that into context for you, this is a more restrictive limitation for this property than what was recently approved. Next, I want to kind of walk through the additional permits that have been achieved on the property. They're listed here. I'm not going to go through the details, but they do represent other local permitting and state agency efforts. And that leads us to the actual existing conditions of the property as it relates to Chapter 12. So I'll start with transportation and access. You asked about State Road 82 and the construction project that is happening just out front of the mine currently. We do have turn lanes. They are being reconstructed so that the trucks can enter the site without impeding traffic on State Road 82. You can see in the center photo our entry and exit from the mine that is paved. It includes truck scales and an administrative office. Those are requirements of Chapter 12. We've met those requirements. And then finally is the truck wash, which was conditioned in 2004. You can see that that's been constructed. A truck that has picked up material has to leave through the truck wash and then the exit. That is to control dirt leaving the property and entering local roadways, also consistent with Chapter 12. I want to pause here for a moment and talk about truck trips. You talked about the traffic associated with the mine. I'd ask you to keep in mind that in the zoning process, we are required to evaluate the worst case scenario. So in 2004, that traffic analysis considered mining the full depth and acreage and the trucks that would be associated with it, regardless of the material. We are allowed to extract all of the material. If you permit the request today, the number of trips will be the same as they were evaluated in 2004 because the quantity of material is the same. Moving on now to preservation and buffering. You heard a little bit about the preserves. I've highlighted them here in green. There's 189 acres of conservation that is required by Condition 4 on page 3. That has been met. We've placed those under conservation easement. The exotics have been removed. The monitoring has been complete, and it's been released by the Department of Environmental Protection. We were required to put in extensive buffering on the property boundaries that were not adjacent to a preserve. That includes a 12-foot berm with landscaping. You can see photos of the existing berming and vegetation here on the site. I want to point out that the adjacent properties to this mine are zoned agriculture. Under Chapter 12, a berm and vegetation are not required for mines adjacent to agriculturally zoned properties. So this condition is in excess of the current regulations of Chapter 12. I included the middle photos so that you can get an idea of the shadowing and the height of that 12-foot berm and the visual separation that it provides to the adjacent properties. The same occurs with the existing preserves. When you combine the buffer and the existing preserves, you have a physical as well as a visual separation from the adjacent properties, limiting any negative impacts. These are very recent photos taken by Mr. Inge regarding the preserves, demonstrating that they've been cleaned up and they are being maintained in that preserved condition. Getting to water quality. This is not a condition of the 2004 approval. And so as part of the request today, we are proposing water quality monitoring to address that deficiency. The graphic on your left demonstrates the locations of the various monitoring wells on site. You can see that there is a well located along the eastern and western property boundary, which we have been sampling for the Department of Environmental Protection, and it is to ensure that those adjacent property owners aren't being negatively affected. What we are proposing is to continue that monitoring effort and to provide the information to Lee County so that you all can also be sure that there is not a water quality problem on site. That data would be provided quarterly, and it would be included with the existing quarterly monitoring that occurs for water levels. Water level monitoring has been occurring on site. We have been providing that information. That is a tenet of Chapter 12 to ensure that water levels do not drop to negative levels. Kirk Martin is here to answer any questions that you have about that. Another item under water quality in Chapter 12 is the topography of the site. That has been submitted. That is how we achieved the development order modification in 2016. If you were to approve this today, we would have to modify that development order and provide that information all over again. So the intent of Chapter 12 and water quality monitoring is being met by the proposal before you today, as well as the existing conditions and permitting. Moving to reclamation, there is currently a reclamation plan associated with the zoning approval. However, we are proposing to expand that reclamation to include littoral shelves adjacent to the entire lake boundary that is adjacent to a preserve. This is meeting more of the intent of Chapter 12. It increases the littoral shelves up to 87% beyond the 2004 approval. So again, coming into greater compliance. When you consider that the planted littoral shelf is adjacent to a preserved wetland, and you calculate the percentage of the lake footprint, you come up with the littoral shelf and the adjacent wetland covering 72% of the lake area. Chapter 12 only requires 25%, so we are exceeding that capacity. The last item is regarding wildlife habitat. This is a requirement of Chapter 12. There is not a condition within the current zoning, and we have not proposed one because the existing preserves are already under easement. You can see from this graphic that the southwest corner of the preserve aligns with the recently approved purchase of the Hermes property, which interlinks with public and private improvements that are proposed in the DRGR area to create a greater interconnected system, not only for flowways and surface water, but also for wildlife. So again, we are meeting that intent of Chapter 12 through the existing site plan and the adjacent properties. Just briefly touching on some of the other conditions from the 2004 approval that will be carried forward, we are maintaining the total acreage of the property boundary. We are maintaining the total acreage of the mine lake. We are maintaining the total acreage of the conservation areas, the maximum depth, and the setbacks. The hours of operation limiting the activities that can occur on site will remain in effect. Any other environmental protection and monitoring that is included in the 2004 approval will remain in effect and is not proposed to be altered. In addition to that, we are expanding the reclamation standards related to littoral shelves and water quality monitoring. It is my professional opinion that these additions and expansions bring the project into greater conformity with Chapter 12. I believe that based on this and the testimony heard from Mr. Baracco, Mr. Inge, and Mr. Schropp, that you can conclude that we have made a proper application consistent with 12109E. We are attempting to clarify a conflict. You've heard a lot about it. Ultimately, it comes down to the fact that we can excavate the material to the full depth and width of the mine. We simply cannot let it move off-site. Allowing the material to be sold would relieve pressure on other properties. You are correct in that front. The existing approvals are generally consistent with Chapter 12. We are offering enhancements that would bring it into greater conformity. With regard to the Lee planned analysis, it was provided in the staff packet. We evaluated this property as an aggregate mine for the purposes of submitting the application. It has been and always will be an aggregate mine. If the property was an aggregate mine in 2004 and found consistent with the Lee plan, that consistency would continue today. I provided an updated Lee plan analysis demonstrating the details for staff to evaluate because, as we all know, the plan has been amended since 2004, and I believe a finding of consistency can continue to be made. At the general, simple crux of the issue, the DRGR future land use permits mining operations. This is an existing mining operation, and it is consistent to allow it to continue. The LEA plan does not differentiate between types of aggregate. That concludes my presentation. I am happy to answer any questions you have about the planning analysis. Mr. Inge does have some follow-up comments to round out our presentation.
Good deal. Commissioners, any questions at this point?
I do.
Yeah, Commissioner Mann?
With the water quality monitoring, if there's an indication of some quality issue, then what? Who has to fix it, or do we shut down the mining operation? What happens if you find a problem?
I believe Mr. Martin can address that. There are procedures in place, and I'll let him describe them.
Right now, the water quality is only required by Water Management District and DEP, so this will be adding it to the Lee County review as well. That water quality is taken quarterly for dissolved oxygen, turbidity, salinity, nutrients, so forth. So the requirements are that if the applicant is causing a water quality problem, the applicant has to fix it by state and local regulations. In this case, what we're offering is the same data will go to Lee County staff as it is going to state agencies right now.
Okay, the burden's on the owner.
Yes, sir.
Operator. Thank you.
Very good. Any further questions? Okay. All right, you're free to close.
Thank you very much, Commissioners. Before my concluding remarks, I would like to address an issue that was raised by Chairman Hammond, and that is State Road 82. As you know, the widening of State Road 82 from I-75 toward the Hendry County line has been ongoing for a number of years and is a fairly substantial project, much needed, much welcomed, and is going to benefit greatly that area of Lee County. Looking at that every day was problematic because, as we've talked about ad nauseum, we can't sell material. I can't sell material for that project. So what we did is to analyze how significant was that issue. So I asked Baracco and Associates to analyze the plans, the specifications, and all the information for State Road 82 for all that work that's been done and is yet to be done. As it turns out, for the material that we could provide from the Bell Road mine, there are 35,000 to 40,000 truck trips that came from the Alico Road corridor, down Alico Road, bless you, down Ben Hill, Griffin, and Tree Line, up Daniels Road, or I-75, either one, to State Road 82. 35 to 40,000 truck trips that could have come right out our front gate and been right on the job site. Now, for the more western parts of the project, we'd had to transport it there. There's no guarantee that we would have been awarded the job to provide that material, but knowing a bit about how construction works, there is a charge per ton per mile that the truck companies charge to move material. I'm on the job site, 3-4 miles away from the job site. The Alico Road, Coarse Road quarries are 15 to 20 miles away. I've got a 6-time haul advantage over them. We probably would have been able to get that work and been able to sell that material and eliminate that number of trips off of your road network, off of our road network. But because of Condition 12, couldn't do it. Now, could I have given the material to the state? I guess, but that's pretty philanthropic and costs a lot of money to do that, so I'm not sure I would have done that. But we would have loved to have been able to sell that material. Couldn't do it.
What about for the future segments?
There's in our application is a letter from one of the contractors on those particular projects begging us to provide lime rock to that job site, to the future job sites. EHC Construction has a letter that's in your package asking if we can, is there any way we can do that? As mentioned, or as Russell talked about, he's outlined why we think we're properly before you today. As reference, he talked about the Florida Rock case that happened back in 2012 where over 40 conditions were addressed, some of them substantive, changing the lake shape and size, access points, providing for the Alico Road corridor, much more substantial. We're just asking for one item to be addressed because of an inconsistency, and that's to be able to sell our material. Carl talked about why, under his professional opinion and under the definitions that he cited, we are an aggregate mine. We produce several types of aggregate material. Finer aggregates or sand, and coarser aggregates or lime rock. Tina talked about the comp plan consistency and Chapter 12. On page 7 of 8, the staff outlined, I believe, 10 items that were of concern from their standpoint regarding Chapter 12. We've addressed every single one of those. All of them are addressed in the items that we've talked about and shown here, ranging from the truck wash to the paved access to the turn lanes to the preservation to the buffers to the water level monitoring. All those things we've addressed. They've been ongoing. Remember, this is an approved mine that's been there for some time. So very briefly, our case is very simple. We mine the exact same lake to the exact same depth with the exact same truck traffic that's already been approved. We clarify an inconsistency in the prior zoning by allowing us to move that lime rock material, the coarser aggregate, off-site and sell it. We increase reclamation, as Tina's slide showed, by 87%, the littoral shelves around the preserve areas. They're minimal now under the current approval. We increase them by 87%. We add a water quality testing regime to our program where, as Commissioner Mann asked, what happens there? We test for a variety of components. In fact, the conditions are designed so that if there is a problem, the onus is on us to correct those problems, which could, I suspect, involve even curtailing operations till we solve it, if it gets to that point. I don't ever think we'd ever let it get that far. We try to address those very quickly, and we take those samples quarterly. All we really want to do is be able to sell the rock that we're already permitted to dig. Nothing else really changes. In our application, we submitted a draft zoning resolution that took the current approved zoning resolution, Z0447, and modified it to update it for all the things that we've done to indicate that not that those conditions go away, but they've been accomplished, and to provide for the changes we've asked for today. So we'd ask that you approve that. And furthermore, we'd welcome the opportunity for you to direct us to work with the county attorney's office to ensure that that draft addresses the items that we've requested today and that it's adequate in nature. And with that, that concludes our presentation. I'd be happy to answer any questions you may have, and I'd like to reserve the right to address any comments that may come up from
We always provide that. Very good. Any questions for the applicant? No? All right, seeing none at this time, let's move to the public comment portion. I have a few cards in front of me. I'd like to call Meredith Budd first, and then after Meredith Budd will be Randy Johnson. Morning.
Good morning, Commissioners. It's been quite a while. Meredith Budd on behalf of the Florida Wildlife Federation. I hope you all are doing well. I know it's been some crazy times. I thank you for the opportunity to speak before you today. I'm here to support staff's recommendation today to deny the applicant's request to change from a dirt mine to the lime rock mine without going through the proper LDC channels. The Federation spoke before all of you regarding the comp plan amendments regarding map 14 and the elimination of map 14. And one of our primary concerns with eliminating map 14 was the potential for approval of lime rock mines that would not go through the appropriate process and, in effect, lack appropriate and meaningful public participation. So today I'm not here speaking on the merit of whether or not the mine should be a lime rock mine or not, but the process of which it's moving forward. It lacks the necessary and appropriate public input that we would have through the hearing examiner process, and that was exactly what the Federation and several others during the MAP 14 process were really concerned about in terms of that missing public participation process. So here we are in step with staff's recommendation to deny the applicant's request. The new lime rock mine should be held to the same standards set out in Section 12 as it pertains to the hearing examiner process. So it should be heard before the hearing examiner and be able to provide adequate and appropriate public opportunities for public participation. So again, we think staff did an excellent job, very thorough review, and we support the recommendation of denial, and we do request that you do the same. So thank you so very much for the time, and good to see all of you.
Very much. All right, Randy Johnson, followed by Beverly Grady.
Good morning.
Morning.
For the record, my name is Randy Johnson. I represent Cicada Seed Corporation. We own the property immediately to the west of Belmont. We're opposed to this application for two reasons. First, we agree that with the staff that the request is not authorized by the Land Development Code. The applicant is trying to do an end around the usual hearing examiner process and to permit a much more intense use without creating an appropriate record with adequate public participation. Second, the change from fill pit to rock mine will create unacceptable impacts to our operation. Bell Road Mine has been a pretty good neighbor up to this point. In fact, I consider Ron a friend. But adding blasting, this is the B word that has been left out of this. Adding blasting and mining accessory uses to the equation will dramatically impact the impacts to us and our countless owners of property within Lehigh Acres north of State Road 82. Historically, the staff and the board have addressed these impacts by requiring substantial blasting setbacks, supported by testimony from experts hired by the county. Bell Mine, on the other hand, wants to leave the regulations of blasting completely up to the state and to avoid meaningful, substantive review of requests by the staff and by county experts. That is completely inconsistent with past practice and unfair to us and other neighboring owners. Blasting within a few hundred feet of our common property line will be hugely disruptive to our facilities and operations. There was good reason why the county specifically prohibited rock mine when this case was heard through the usual hearing examiner process. Please follow the law and past practice and require that this application go through the MEPD process. Thank you. Also, I'd like to say, I'd like to thank the county for the purchase of the Hermes property to our south. Every little bit of buffer helps.
Thank you. Beverly Grady, and that's the last card that I have. Thank you.
Good morning, Beverly.
Will you make sure the clerk gets a copy too?
Oh, I do. I have
Perfect.
Yes.
Okay.
Good morning, Ms. Grady. How are you?
Thanks, Beth.
Good morning. For the record, I am Beverly Grady with Rezoning, and I represent the owner to the east of the Bell Mine project, and Richard Uby, who is here today, and Eden's Team LLC. We have filed a letter, has one handwritten change. I'm going to call this the Eden parcel as the neighboring parcel. This Eden parcel is found to have residential use. In fact, it was this very case in 2004 that residential use continues and has been expanded. There's a second dwelling unit. This parcel was found to have residential use in the old Corkscrew Plantation case, which I want to incorporate by reference the hearing examiner decision and the staff recommendation and the staff report on that. And this parcel also contains a water ski facility that has training. It was approved by this board. And this application, which was approved in 2014 and has conditions that only relate to a fill dirt operation, needs additional conditions that would protect the surrounding property owners. We would also agree with and incorporate the comments that were just made by the prior speaker. The adopted 2004 conditions are only for fill dirt. We need additional conditions. Before you vote, I would request that you read Attachment I to your staff report. That is the hearing examiner report in the 2004 case. In my letter, I have attached the 2004 Board of County Commissioner minutes. I would ask that you read that. We don't need the attorneys, myself included. It's pure English. This case, the applicant, the HEX, the staff report only asked for a fill dirt operation. That's all that was reviewed. That's all that was approved and recommended by the HEX and approved by this board. It's clear English. I would request, there's a process. No doesn't mean no, it means just use the process recommended by staff. And that's what we ask for you today. The staff has not reviewed this request, and this has dramatic impacts because there was no blasting. That's in the record 2004. It was fill dirt only. It was only incidental rock crushing for those loose rocks brought up during the excavation. It's all in the record. It's pure English. There's no legal interpretation. It is factual. And there is a process for them to get what they're requesting, but it is not this process to turn this fill dirt operation into a full-blown blasting rock operation. They need to follow the process. That's what we would ask for you. We need your protection for those citizens who understood this was an 8-year fill dirt operation. They can come in and ask for these changes, but not ask for a full-blown mine that's had no review since 2004. Commissioner James said on the record, I would not vote for this if it was a rock mine. It's in your minutes. So we're ending at 3 minutes, all right? It just points that there's not been sufficient opportunity in this case to provide our testimony.
Ms. Grady. Okay, raise your hand if anybody else wants to speak in public comment on this one? Anybody else? All right, I'll close public comment. Does the applicant wish to address anything?
I could, just 2 minutes real quick. First of all, with regard to the process, as I indicated before, is separate and apart from other processes that are in the code, and it's here for this specific type of application. This process existed before you eliminated MAP 14. It was adopted back in 2012, I think, as a process, so it's been in the code for quite some time now, and public participation is available through this very proceeding. This is why it's scheduled, and this is why it's open to the entire public. There was no end around proposed here or facilitated here. This is basically in addition to the processes that would otherwise be available under Chapter 12. This is a fully recognized process that has been used before. With regard to blasting was addressed in 1991 and was approved in 1991, and now the state has preempted regulation of blasting to the state fire marshal. So the blasting was previously considered as part of this operation. And finally, with regard to Ms. Grady's comments, I think we went through it in our case in chief, and Mr. Jacob agreed that fill pit is not a use under your zoning code. What was approved in 2004 was excavation, mining, which allows for the extraction of all materials as part of the operation. And that covers all manner of materials that are found under the ground. Limiting to a fill pit operation simply wasn't possible and actually accomplished in 2004. That's my rebuttal. Thank you. If you have any questions, I'm happy to address them.
I do.
Yeah.
And you touched on it, but I'm still in a fog as to blasting and what the new rules and regs are. You made reference to the state now controls blasting and whether they're going to be able to do it under what circumstances. I need a little comfort for Ron's good friend back there as to what's going to happen in the blasting arena.
We do have our blasting consultant here.
I'd like to hear from him if that's all right.
Yeah. They bring up Jeff Straw from Geosonics because he'll be able to address it better than I.
You're a blast man. You had him there just waiting for me. Okay.
You could ask the question.
Mr. Chair, Commissioners, for the record, Jeffrey Straw, I'm Vice President and Area Manager of Geosonics. We are seismologists, consultants in vibration acoustic. And Commissioner, Mr. Jacobs is right. The state took over control for commercial mining operations of blasting in the state of Florida. They did that in 2000. They promulgated rules in 2001. It requires inspections by the state fire marshal. It requires an annual permit by the state fire marshal. There is a complaint response by the state, so if there is any complaint from anyone related to, typically it's vibration or air blast or something related to blasting, the state fire marshal's officers investigate that and evaluate it. There is a claims program that was put in, I don't know, probably about 7 or 8 years after the initial regulation, so that there is a process to go through the hearing examiner. If there's something that the quarry can't address directly, there is a legal process for them. The mine puts up a $100,000 continual replenishment bond. The blasting contractor, whoever is working on the site, has a duplicate bond. So there is no issue of funds running out or anything like that. Those are maintained through the state fire marshal for any amount that the hearing examiner would come up with. Blasting follows pretty much the rules, 8 a.m. to 5 p.m., Monday through Friday. No blasting on legal holidays. It requires a firm similar to us to be retained. so that there is a third-party independent company actually monitoring what goes on in terms of the use of explosives. All of the explosives people are licensed by the state, so that anyone that handles it. In this type of operation, nothing is stored on site. It's brought, there's a drill that drills specific number of holes. They load those holes. Everything else goes back off the site at the end of the day. It's controlled by independent people. There is monitoring of all the vibration and noise levels that are produced. Typically, in this case, those are at the closest structures. In a preliminary look at this, the water ski area would be a location, probably a location to the north would be, depending on where they are in those operating pits as they move around. In a nutshell, that's pretty much the state's, has sole exclusive control over it. I don't know if there's anything else specific that I can answer, but I'll certainly try.
Any further questions on that?
I think that was a pretty good summary.
Commissioner Pendergrass?
Brought me up to speed. Thank you.
Thank you.
My question, you can say, this is for county attorney. So under the current conditions before today, could they get a permit to blast now for dirt that they're already approved for?
From the county standpoint, the county doesn't regulate blasting. Right. It would be up to them to get their permit from the state, and assuming they meet state requirements, they could get that and blast.
So before today's request, they still could use blasting to get to dirt. They were approved to down to 40 feet.
As far as the county's concerned,
Right,
yes.
so the county would not interfere. We could not stop them from blasting today or yesterday.
Correct.
Right, in the future, we couldn't either because we're preempted.
Correct.
Thank you.
Just real quickly, I know a lot of people have concerns about blasting. The other method to get the rock out is a hammer, right? That just kind of like bangs over.
Exactly what you're doing all day long.
All day long.
As
And
I
how long does a blast last?
Typically, the blast duration is less than 1 second for the detonation. The vibration may be 2 to 3 seconds worth of what we actually can record. But for a punch bar, and it's my understanding that that material that's in your photograph was used by a punch bar going all day long. And you get to a point where it's not effective. So they could never recover likely 240 feet. You recover surface materials and excavate, but a backhoe can't dig that far, and a backhoe can't actually dig the material.
Okay. Any further questions at all? No? Does the
Thank you.
applicant have any more they want to add?
Nothing more. We did present a resolution for your consideration. If there's work that needs to be done, we're happy to work with the county attorney's office on.
All right, I'm sure if commissioners have any other questions, we'll be able to ask them to y'all. So at this time, commissioners, we've heard the presentation from the staff, the applicant, the public, and it's time for board discussion or consideration of this item. So who would like to talk on this? Yeah, Commissioner Sandelli?
Yes. I always try to look for some clarity, especially if it involves the law. We've heard from our counsel and so on and so forth, and there's some clarity and there's certainly some questions here, And so I think for me, when I go from the law to interpretation, I try to defer to some common sense. And what does that common sense, tell me? And I think we've established the fact that there's materials in aggregate mine, so I think I'm comfortable with that. Looking from the pictures so what's the alternative once you pull this out of the ground? What do you do? Do you store it on site? I mean, if nothing else, I think there's some questions that were raised. I'm not a geologist or chemist, so I don't know that. Moving it off-site to what, to where, to whatever, just see whatever. Pushing it back in the hole, I'm not sure that makes much sense, And so we have a product here that's of value, whether it's to us here or potentially of value somewhere else. And so from a common sense approach, how do we take advantage of that need that we have here or someone else has it somewhere else? So I wish there was some additional clarity, but I think stepping from the law to kind of a common sense type thing, that's where I'm at right now.
And I kind of touched on what Commissioner Sandelli said. We've got a rock star team here as far as our staff goes, and I understand their concerns, and that's why I wish it was a little bit more clear. But like Commissioner Sandelli said, it's a common sense. When you see this picture and you see this material, and there's only one ask here today, is to sell that product they're already allowed to permit it to. Now, understand on the other side, there's people that wish the whole process would go away. They wish the whole mining issue would go away, but it's already approved since 1990, so we cannot change that. They're already digging it up, they're already excavating, they're already storing it on site, so what do you do with it from there? And I think that's the most important thing, is what's the ask of the board today? Either allow us to sell it or not to sell it. And I think that's what we have to focus on, what we're being asked for today. Understand that the story will probably be written different tomorrow, that we approved a mine or something that was already approved, but at the end of the day, the request is to sell the product that's already been allowed to be permitted to sell and to be moved. And I understand I have some concerns about the water quality issues on both sides, and those have been clear to me now, so I feel comfortable with that now. And I would totally support the resolution. I'd like to see that I like knowing that the acres are preserved. I like seeing that there's more water quality monitoring going in this effort now, because currently it's not being monitored, so it actually has an element of water quality monitoring. So I would move to accept the applicant's request to move forward with this, the resolution.
Okay, so motion for approval of the applicant's request from Commissioner Pendergrass and a second from Commissioner Manning. Just let's ask Mr. Jacob, is that sufficient?
I need to add a couple findings just to the resolution to make sure we're clear.
Okay.
If you could, as part of your motion, that you find that the current approvals in 2004 permit the extraction of natural resources, including aggregate, and that the proposed request meets the requirements of Chapter 12, Section 109E, and that the proposed conditions and extension of the duration and any changes to the master concept proposed during this request is in greater conformance with the existing regulations under Chapter 12.
So does the motion maker amend his motion to what Mr. Jacobs just stated?
I will amend my motion to include that language, and also there's no other changes. So as far as the being, in my backyard attitude, this is my backyard, is that there's no other changes, no extension of depth, there's no more than 40 feet.
All other conditions as proposed and addressed in the resolution that was attached to you will result in the actual resolution presented to the chair for execution.
Very good. And so the seconder agrees?
Yes.
Okay. So the motioner and the seconder agree on the motion as outlined by our county attorney. Do we have discussion on this motion? Commissioner Mann.
Yeah, I always like to wade in here just before we vote on these things, so let people know what I'm thinking. I think you're entitled to know our thoughts, and I appreciate the commissioners that have spoken already, and you've spoken through a motion or a second. Every time we have a meeting like this, I bring with me my little mental environmental barometer. And I wave the green flag, and y'all have seen me wave the green flags many times, and I listened carefully when I was briefed on this by our more than competent staff. Thank you very much for that. But in the final analysis, with my little mental environmental barometer working as fast as it could today, I'm trying to look ahead, say 50 years, even 100 years. And if we approve this request or not, what will those people who view this environment 50 years from now, what will they see differently? Since we're going to dig the same depth and the footprint and everything else seems to be identical. There's no surface water flow that I'm worried about, and I think the retained water will be, other than deeper, it's the same boundaries. I can't work myself into a major concern about an environmental impact any worse than what today's operation consists of or creates. So with some concern, yes, but not enough to have me oppose the motion. I find myself in support of what y'all are suggesting here. Thank you.
Any further discussion then, Commissioners? All right, seeing no further discussion, are there any objections to the motion? No objections, that motion carries unanimously, and we have no further business before us, so we're adjourned.